I call Lewis Wall.
Tēnā koe te māngai o te whare. It is my pleasure to speak on this, the third reading of the Coroners Amendment Bill, and I'm going to outline why the Labour Party is not supporting this piece of legislation. And I really want to start after going on the Coroners website and looking at what coroners do. So I want to take the time to mihi to our coroners. They do an incredibly important job. And what they do is help determine when, where, how and why a death has happened in Aotearoa, New Zealand. And what they also try and do is work out whether anything can be done differently that might prevent similar deaths in the future. So I want to emphasise that. They want to identify if there's anything that we could have done to have prevented a death. And in fact, I think that is one of the most significant roles of the coroner, in addition to ensuring that families have the information and know what has happened to their loved ones. So it's very much about an individual good, I suppose you'd call it, the individual's families, understanding what has happened to their loved one, but also they have a responsibility in terms of our collective or public good. And those essentially are why coroners make recommendations. So I'd like to highlight the supplementary order papers of my colleague Jacinda Ardern that were actually rejected in the committee stage debate of this House. They were 145 and 146. And essentially what they said was that persons or organisations or government agencies, Mr Speaker, must respond to coroners' recommendations. And where did that come from? Actually, the Law Commission wanted to support it too. And I want to note a particular University of Otago research by Dr Jennifer Moore and Professor Mark Hennigan. Dr Moore actually has a public health degree as well as a law degree, and her piece of research focused on the effectiveness of New Zealand's Coroners Court. Her rationale was that the coroner's work is extremely important and that the recommendations save lives and guide policy. So what she did was investigate coroners' cases and recommendations from 2000. So remember, this Act started in 2006, so her research was from 2007 to 2012. And what she did when she attempted to ascertain what happened to those recommendations, she was actually mystified is probably the best word, because what she found is that the Coroner's Court do not report annual law reports. So she found that intriguing and spent months travelling around the country, going to different courts and gathering data herself. And so what she found in that 5-year period was that there were 607 cases. There were 1,644 recommendations that involved 309 parties, and of those, 121 government organisations. So what did she do? She contacted them. And of those she contacted of the 309 parties, 200, 79 agreed to be interviewed, and a further 42 completed a questionnaire. And essentially the key finding of her piece of research was that a mandatory response regime should be put in place to ensure that organisations responded to coronial recommendations. Sounds pretty simple. And what Dr Moore has continued to do is to engage with coroners and to work with them, because one of the other findings of the research was that some of the recommendations weren't targeted enough. So they weren't specific enough about who should actually do something to prevent deaths in the future. And that's become an ongoing piece of work that she's engaged with. And in fact, the coroners themselves said that sometimes they made recommendations in a vacuum. So this two-way process that she wanted to create, and that my colleague Jacinda Ardern had suggested, has been rejected by this House. And that's a sad thing, Mr Speaker. The other part of the process that we've gone through that I wanted to highlight was the supplementary order paper of my colleague, the Honourable Phil Goff. And essentially what his supplementary order paper would have done was to continue the presumption that coroners would investigate military deaths unless the Attorney General directed the coroner not to, as opposed to what this legislation will create in the future was that coroners can't investigate military deaths unless they are directed by the Attorney General. Now, the rationale for coroners continuing to investigate military deaths actually were highlighted, and they were highlighted in a Stuff article actually titled "Secret Death Panel Planned," and within that particular article was quoted former Army medic Sarah Erb, and she was the partner of Corporal Luke Tamatea. Now, Corporal Luke Tamatea was killed in action in Afghanistan in 2012. And I want to highlight Corporal Tamatea's situation because in that instance there was a coronial inquiry, and there was also a court of inquiry because it was a military death. And what we know from what Corporal Tamatea's whānau have said, that because of the coronial report, the whānau actually received a copy of that report. And having read that report, they got the answers that they were looking for. And there was a particular emphasis in this article about Corporal Tamatea's mother actually receiving the answers that she needed to get some closure, because her son died not in Aotearoa, but in Afghanistan in the line of duty, and she was mamai. She was feeling because she didn't know what happened to her son. And so I think all of us would agree that it's incredibly important for families to be able to understand what happened to their loved ones so that they can answer all the questions they may have, and then they can actually process that, have closure, mourn, grieve, and then get on with their lives. And I think a number of us would agree that unless you get closure, it's very difficult to move on because you have a whole lot of unanswered questions. I want to contrast that, however, with the Court of Inquiry and the record of proceedings, because there was also involvement of the military, because in any military death, there is a Court of Inquiry, and I spoke about this in the committee stage. I wanted to look at a supplementary order paper, actually, Mr. Speaker, but because the governance of military deaths, courts of inquiries are actually enabled through the Armed Forces Discipline Act of 1971, I couldn't. Because one of the things that I wanted to ensure was that family members had access to the record of proceedings when there is a court of inquiry because of a military death. And the reason I want to particularly focus on this is that I asked at committee stage for the Minister and the Chair to confirm that if there is a military death and if the only inquiry into that death is a military court of inquiry, that families have automatic access to the record of proceedings. So no minister got up to refute my assertion, and in fact I want to highlight that the chair of our select committee, Jackie Dean, was in the House at that time, and she said I was wrong. And so I'm taking her on her word, and so I want it recorded in the Hansard that it is the expectation of this House that if a military court of inquiry is the only inquiry undertaken, that family have automatic access to that inquiry, to that record of proceeding, so that whānau can have those questions answered, they can get the closure that they need, and that they can move on with their lives. And other than that, I hope that I've clearly outlined why Labor is not supporting this legislation. Finally, I really enjoy my membership of the Justice and Electoral Select Committee. I think we have incredibly robust discussions, but we do because we're talking about law and we're talking about matters of principle and matters of policy. And so I hope the people of Aotearoa, New Zealand understand now why the Labor Party do not support the Coroners Amendment Bill. Thank you, Mr. Speaker.
Members, this debate is concluded. The question is that the motion be agreed to. Those of that opinion will say aye. To the contrary, no. The ayes have it. Party votes called for. I'll ask the clerk to conduct a party vote.
New Zealand National.
59 in favour.
New Zealand Labour.
32 votes opposed.
Green Party.
13 in favour.
New Zealand First.
12 votes in favour.
Māori Party.
2 in favour.
Act New
1
Zealand.
in favour.
United Future.
1 in favour.
Members, the ayes are 88 and the noes are 32. The motion is agreed to.
Coroners Amendment Bill, third reading.
Call on government orders